Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline lawyer, and this is another episode in our series entitled, There's a Form for That. And I'm joined by Camden Schutte. Who are you?
I'm Camden Schutte, the designated broker for Coldwell Banker 360 team and 360 Property Management, and we'd be in Fidalgo Islands.
And the inspiration for this series, so therefore he has to take part in presenting this series. Today, let's talk about, let me set the scene before I give you the form number. We'll test you and see if you can figure out which forms to use. I am the buyer broker, and I'm writing an offer on property that is tenant occupied. So the seller is selling a home and the tenant is still living in the home. Mm-hmm. I'm writing the offer in addition to all of the forms that I am going to choose to include for my buyer. What form should I absolutely include?
Well, if you have a tenant in the home, you're probably going to have a lease on that home, so you want to make sure you include the lease review, and I believe it's 22L. 22L,
as in lease.
Yep.
Right? So understand that this is a form for limited use. It's form 22L. The title is Lease Review. If you're selling a duplex or a triplex or a fourplex, something like that, you're not going to use 22L. Why? Because you're going to use the multi-family purchase and sale agreement, which I think is Form 20.
Sounds right. Don't hold me to it, though.
I think it's Form 20. But you're going to use the multi-family purchase and sale agreement if you're writing an offer for the sale of anything greater than a single-family residence. So 22L has a very specific but limited purpose. You're writing an offer on a single-family residence that's tenant-occupied.
Correct.
This is not a scenario where seller's living in the property and they're going to hold over or lease back. That's different form. There is a form for that also, but we're not talking about that in this episode. The form we're talking about is the form you use when single-family residence has an existing tenant occupant and your buyer is going to take possession with that tenant. I'm sorry, your buyer's going to take possession, but the transaction is going to close with that tenant in possession.
Correct. And keep in mind, it's different than, I think it's on the optional clauses. There's a leased property review period. This is different. We're not talking about leased property like a propane tank. We're actually
I didn't even know you were talking. I was going, what?
We're talking about a lease. So a lease that a tenant has wouldn't be covered under that section. You'd still want to make sure you use this form.
Right.
As long as that tenant is staying in place. When you buy a property with a lease already on it, you become the new landlord of that, and you want to know what you're getting into.
Which leads to a different conversation, but let's just close the loop really fast on 22D. There is a personal property section in 22D. If seller has personal property in the home that is leased,
correct,
like a satellite dish, for example, that's the provision in 22D that Camden was referencing, and he's exactly right. If you've seen brokers use that for the purpose that 22L fills, right. That's funny, I'd never seen that before. So 22L is a set of provisions that buyers should be thinking about if they're going to buy tenant-occupied property, single-family residence. Like, what does the lease say? What are the terms of the tenant's lease? Is it a term lease? Is it month-to-month? How much is the tenant paying? All of that is information that buyer brokers, you want to make sure your buyer has access to before they agree to be bound by the purchase and sale agreement. So 22L creates a contingency for the buyer to get all of that information from the seller and then terminate the purchase and sale agreement if they're not satisfied with what they review.
Absolutely. And just, maybe a buyer plans to move into the home when the lease expires. Well, that lease could still be a month or two after closing. Mm-hmm. You're still going to be subject to that lease as the landlord. You still want to make sure you look at it, even if you don't intend to continue using it as a rental property.
Exactly. And that leads to the next conversation, right? We can't have any conversation about a tenant-occupied property without reminding brokers of the risks associated with any person becoming a landlord in Washington State. So if the buyer is going to purchase the property as for the purposes that Camden just described, thinking that they're going to move themselves and that the tenant's lease is going to be expired in 2 months and surely the tenant will move out then and then the new buyer will, not so fast.
Yep.
the tenant may not agree with that protocol. The tenant may not want to move out. The tenant may make it very difficult for the buyer to move them out. Yes, there is a just cause to move that tenant, to terminate that tenancy, if in fact, at the end of that lease term, the buyer wants to occupy the property personally. But just because that satisfies one of the just cause reasons doesn't mean that they're going to get the buyer out easily. So in that scenario, brokers should advise buyers to seek legal counsel.
Use the 22L so you can get a copy of the lease to go take to an attorney to review for you.
Exactly. And also remember that if the buyer is purchasing this property with a tenant so that the buyer can move that tenant out and then spend some money on the property, rehab it, and put a new tenant in at a higher rent, there is no just cause for that. There is no basis for your buyer if that is their plan, to terminate the existing tenancy, and once it goes month to month, terminate that tenancy, move that tenant out, and then re-rent the property after they've rehabbed it at a higher rate. There's no just cause for that. You can't do that.
Which is a great reason. All of these are great reasons to make sure that you use the 22L, get a copy of the lease, look at what your buyer actually wants to do with the property, advise them to talk to an attorney, and let them see if they can actually do what they want to. And this gives them an opportunity to terminate the transaction if they're not able to do that.
Yeah. Read the form so that you know that that the buyer's following the timeline
That's right.
available to them.
And on single family properties only, otherwise use the multifamily purchase and sale agreement.
Exactly. And then there's one other form that's not referenced in 22L. Camden actually mentioned this one to me, but you're right. There's one more form kind of associated with this topic that I've never used. I've never seen anybody use. And what is that form number?
It's a form 69. It's an assignment of lease. So if there is a lease on the property, as the buyer, the new owner, you automatically become the landlord. But for everybody's sake and clarity's sake, that lease should be assigned to you as the new landlord, and that's where Form 69 comes in.
Exactly. So at closing, Form 69 should be executed by the seller to the buyer, assigning the lease rights for the landlord to the new buyer.
Absolutely.
If you have questions on this topic or any other, please visit warealtor.org, click the link for the legal hotline, and ask me a question. Thank you for being a Washington REALTORS member.